If I stopped 100 people on the street right now and asked them what the U.S. Constitution says about the size of the Supreme Court, I mean, almost all of them would confidently say, it says there have to be 9.
Oh, absolutely. They would assume it's written down right next to the age requirement for the president.
Right, like it's just a hard rule etched in stone, along with the 2-term limit or something.
Exactly. But they'd be entirely unequivocally wrong, because if you read the actual text of Article 3 of the Constitution, it is completely, terrifyingly silent on the matter.
Wait, it just doesn't say.
It simply mandates that there shall be, quote, one Supreme Court. That's it. It doesn't say if that court should have 3 people, 9 people, or, 50 people.
Okay, here's where it gets really interesting, because as anyone who studies political history knows, if you leave an ambiguous blank space in a government document, politicians are going to fill it.
Oh, they're going to use it.
Yeah, they'll weaponize it. And that brings us to the sources we're diving into today. We have this fascinating historical dossier tracing the size of the Supreme Court.
And it really shatters the modern myth of the court as this, purely neutral, untouchable umpire.
Right, because throughout American history, the number of justices on the bench hasn't been a matter of divine constitutional geometry. It's been this wildly fluctuating number, pulled back and forth like a political lever.
Which raises an important question about how we view judicial independence today. We operate under this assumption that the court is totally insulated from the bare-knuckle brawling of the legislative and executive branches.
But the history in this deep dive forces a much more uncomfortable reality, doesn't it?
It really does. I mean, from the very beginning of the Republic, Congress and the president have treated the physical dimensions of the court as contested terrain. It's a prize to be won.
Right. Expanded to reward an ally or shrunk to starve an enemy.
Exactly. So to really grasp how the number 9 became cemented in our minds and why modern debates about the court's size sound the way they do, we have to trace the seesaw all the way back to the start.
Let's do it. Let's go to 1789, the first Congress. They have a brand new constitution, but they don't have a functioning court system yet.
Right. They passed the Judiciary Act of 1789, and they decide the Supreme Court will have 6 justices, a chief justice, and 5 associates.
6. Which is an even number.
Yeah, which is fascinating because modern legal thinkers abhor an even number on a high court.
Well, yeah, an even number invites a tie.
Exactly, and a tie leaves the lower court's ruling in place without establishing a national precedent, which is basically the whole point of a Supreme Court.
So why 6?
Because the first Congress wasn't primarily concerned with tie-breaking on massive nation-defining cases. They were concerned with logistics.
What kind of logistics?
Well, you have to remember what being a Supreme Court justice meant in 1789. You didn't just sit in a marble temple in Washington, D.C. reading briefs all day. Oh, right. You had to physically ride circuit.
Exactly. Congress divided the new nation into 3 judicial circuits, Eastern, Middle, and Southern.
Okay.
And the Judiciary Act required 2 Supreme Court justices to be assigned to each circuit, where they would hold court alongside a local district judge.
So 3 circuits times 2 justices each equals a 6-member Supreme Court.
Yeah, it was just a mathematical formula derived from geography.
And we really need to pause on what riding circuit actually entailed for these men, because it paints a picture of why this administrative formula had to keep changing.
Oh, it was awful.
Yeah, I mean, this wasn't boarding a train or a plane. This was the late 18th century. These justices, many of whom were older men, had to travel hundreds of miles through mud, snow, and unpaved wilderness.
Mostly in stagecoaches or literally on horseback.
Right, staying in awful taverns, dealing with terrible weather. They frequently got sick. The physical toll was brutal.
It was so brutal that some prominent figures outright refused the job, or they resigned after a few years, specifically because they couldn't handle the travel.
Wow.
So when we see the court expand over the next few decades, the primary justification is always geographical necessity. Like in 1807, Congress adds a 7th seat to the court.
And that's because the nation was pushing westward, right, into Ohio, Kentucky, and Tennessee.
Exactly. They needed to create a new 7th Circuit to handle the legal business of the frontier.
Okay, looking at this timeline, adding seats for westward expansion makes total sense on paper. The country gets bigger, you need more judges to ride out into the new territories.
Right, it seems perfectly logical.
By 1837, the country has expanded even further. Andrew Jackson is president, and Congress expands the court to 9 justices to cover 9 circuits.
Yeah, and then during the Civil War in 1863, Abraham Lincoln is in office, and Congress bumps it to 10 justices to cover a new 10th Circuit spanning California and Oregon.
So if you only look at the map, it looks like simple logistical housekeeping.
It is the perfect administrative cover story. But the political reality was always running parallel to the geographical one.
Here we go. Right. Every time Congress added a seat for a new circuit, they were simultaneously handing the sitting president a massive political gift, which is the power to appoint a new ideological ally to the highest court in the land.
And the politicians of the 1800s knew exactly what they were doing.
They were fully aware that this structural tool could dictate the ideological direction of the judiciary.
Like with Andrew Jackson in 1837. He was a populist who despised the nationalist, federal power-centric jurisprudence of the old John Marshall Court.
Exactly. So by expanding the court from 7 to 9 at the very end of his presidency, Jackson got to pack the bench with Jacksonian Democrats who shared his states' rights philosophy.
He fundamentally altered the ideological balance of the court under the banner of Western expansion.
And Abraham Lincoln in 1863 provides another crucial example. Adding a 10th seat for California wasn't just about the gold rush population boom.
No, the country was in the middle of a massive civil war.
Right. Lincoln had implemented unprecedented, legally dubious executive actions, like the blockade of southern ports. He desperately needed to ensure that the Supreme Court wouldn't strike down his war measures.
Because if the court rules the blockades unconstitutional, the Union war effort potentially collapses.
Precisely. By adding that 10th seat, Lincoln was able to appoint Stephen J. Field, a reliable Unionist from California.
So he secures an anti-slavery pro-Union majority on the bench.
Yeah, it was an ideological insurance policy masked as a geographical necessity. The framers' ambiguity left this loophole wide open, and throughout the early 19th century, presidents and Congresses used it to gently tilt the scales.
But I'm thinking tilting the scales is one thing. Completely breaking the mechanism to destroy your political rival is another.
Right.
Up until the Civil War, they were just adding seats, adding chairs to the dining room table as the family grew. But someone in Congress must have realized that if they possessed the power to give a president a seat, they also possessed the power to take a seat away.
And they realized it in spectacular fashion right after the Civil War. This is the moment the administrative mask fully slips off, revealing the raw, bare-knuckle politics underneath.
So if they were just adding seats for practical reasons like westward expansion before, when did this turn into raw politics? Let's look at the climate of Washington, D.C. in 1866.
Okay, so Abraham Lincoln has been assassinated. His vice president, Andrew Johnson, inherits the White House.
And Johnson is a Southern Democrat who was only put on the ticket with Lincoln to show national unity, right?
Exactly. But now he is overseeing Reconstruction, and he is fiercely clashing with the radical Republicans who control Congress.
To simplify this for our listeners, imagine a high school principal, that's President Johnson, and the student council, that's Congress, and they absolutely hate each other.
That's a great way to look at it.
The principal has the power to appoint the faculty advisors for student clubs. But to stop him, the student council just abolishes the clubs until a new principal takes over. Then they bring the clubs back. It's a pure power play.
It really is. Congress wants to fundamentally reconstruct the South and enforce the civil rights of newly freed slaves. But Johnson wants to be lenient on the South and is actively vetoing Congress's civil rights legislation.
So the animosity between the two branches is absolute.
It is a state of total institutional warfare that would eventually culminate in Johnson's impeachment. And right in the middle of this toxic standoff, a vacancy opens up on the Supreme Court.
Because Justice John Catron dies. And remember, the court is at 10 seats at this point, from Lincoln's 1863 expansion.
Right, so Johnson nominates Henry Stanbury, his highly capable attorney general, to fill the seat.
And the radical Republicans in Congress look at this nomination and realize they're in a bind. They're terrified of Johnson having any generational influence over the judiciary.
They believe his sympathetic views toward the former Confederacy will ruin Reconstruction, but just voting down his nominee isn't a permanent solution.
No, because Johnson could just keep sending up nominees, burning through the Senate's time and patience.
Congress needed a structural solution. They needed to cut off the president's power at the source. So they passed the Judicial Circuits Act of 1866.
And this piece of legislation is one of the most audacious maneuvers in American constitutional history. I try to visualize this like a game of chess between the president and Congress.
Okay, let's hear it.
The president has a pawn, which is his constitutional power to appoint a justice when a vacancy opens. Congress can try to block the pawn by voting against the nominee.
Right.
But in 1866, Congress realized they didn't have to just block the pawn. They realized that because the Constitution doesn't specify the size of the board, they could just remove the squares entirely so the pawn has nowhere to move.
That is the perfect analogy. The 1866 Act didn't just reject Johnson's nominee, it explicitly shrank the size of the Supreme Court.
Wow.
Yeah, the law mandated that the next 3 vacancies on the court would simply not be filled, gradually reducing the number of justices from 10 down to 7.
So they legislated Andrew Johnson's appointment power completely out of existence.
It was legislative starvation.
It's astounding. We talk endlessly today about the fear of court packing, a president adding seats to flood the zone. This was court shrinking. Congress simply deleted the vacancies to spite the chief executive.
And it worked. Johnson served out the rest of his term without making a single Supreme Court appointment. The number of justices drifted down as men retired or died.
But the true cynicism of this maneuver becomes glaringly obvious just a few years later. By 1869, Andrew Johnson is out of office. The political winds have shifted.
Yep, Ulysses S. Grant, a Republican hero, closely aligned with the congressional majority, takes the oath of office.
And suddenly, miraculously, Congress decides that a 7-member court is woefully inadequate for a growing modern nation.
The squares on the chessboard reappear.
Exactly. They passed the Judiciary Act of 1869, which bumps the number of justices back up to 9.
Just in time for their ally, President Grant, to immediately fill those newly recreated seats with 2 Republican loyalists.
So when you look at the sequence of events, 10 seats under Lincoln, shrunk towards 7 to paralyze Johnson, bounced back to 9 to empower Grant, you realize that the number 9 has absolutely no inherent constitutional magic.
None at all. It was established in 1869 not by divine inspiration, but by raw, partisan Reconstruction-era maneuvering.
When you hear politicians today lecturing about preserving the quote-unquote historical norms of the court, think back to this exact moment. The norm in 1866 wasn't 9.
No, the norm was whatever Congress needed the number to be to win the political war of the day.
The only reason 9 stuck after 1869 is because doing this, every single election cycle would destroy the public's faith in the judicial system entirely, right?
Exactly. A kind of unwritten truce formed. Politicians realized that if the court became an obvious revolving door puppet of the legislature, its rulings would lose all legitimacy.
It became a stabilizing tradition. For nearly 70 years, through the Gilded Age, World War I, and the Roaring '20s, the number 9 held firm.
But as history shows us, unwritten truces only survive until the socioeconomic stakes become too high for politicians to tolerate.
Which brings us to the 1930s. Congress proved in 1866 that shrinking the court could thwart a president. But 70 years later, a president would try to use that exact same lever in reverse.
Right. Instead of Congress shrinking the court to starve an executive would try to explode the court's size to bulldoze a hostile judiciary.
We are talking about the great constitutional showdown of the 20th century, Franklin Delano Roosevelt versus the Supreme Court.
To understand why FDR felt pushed to take such a nuclear option, we have to grasp the sheer desperation of America in the 1930s. It wasn't just a political disagreement, it was an existential crisis.
The country was in the depths of the Great Depression. A quarter of the workforce was unemployed.
Industrial production had collapsed. Thousands of banks had failed, wiping out the life savings of millions of families. People were starving in bread lines in major cities.
When FDR took office in 1933, the capitalist system itself seemed on the verge of total collapse.
FDR responds with the New Deal. It's a massive, unprecedented tidal wave of federal legislation. He is creating agencies to regulate industry, guarantee bank deposits, establish minimum wages.
Paying farmers to manage crop yields, all of it.
Yeah.
He is fundamentally reimagining the role of the federal government in American economic life.
And the public overwhelmingly loves it. By the 1936 election, FDR wins a mandate that is, frankly, unimaginable in today's political climate.
He wins 46 out of 48 states. He crushes his Republican opponent in the popular vote. He has supermajorities in both the House and the Senate.
The democratic machinery of the United States was unified in a single direction, screaming at the government to take aggressive action to alleviate the suffering.
But FDR had one immovable roadblock standing in his way, right? The Supreme Court.
Specifically, a deeply entrenched conservative bloc on the court that the press had nicknamed the Four Horsemen.
Justices Willis Van Devanter, James Clark McReynolds, George Sutherland, and Pierce Butler. These 4 men are the central antagonists of this era. What was driving them? Why were they so fiercely opposed to everything FDR was trying to do?
Well, to understand the Four Horsemen, you have to understand the jurisprudence of the late 19th and early 20th centuries, an era often referred to as the Lochner era.
Right.
These men believed fervently in a highly restrictive view of federal power. They viewed the Constitution as a charter of negative liberties, specifically designed to prevent the government from interfering in the free market.
So they weren't just partisan hacks trying to ruin FDR's day. They genuinely believed that the federal government micromanaging the economy was a stepping stone to tyranny.
Absolutely. Their legal philosophy rested on two main pillars. The first was a very narrow interpretation of the Commerce Clause.
The part of the Constitution that gives Congress the power to regulate commerce among the several states, right?
Yeah.
Interstate commerce.
Exactly. The Four Horsemen drew a hard, rigid line between commerce that crossed state borders, like a railroad, and activities that occurred wholly within one state, like manufacturing or agriculture.
Okay, what was the second pillar?
The second pillar was freedom of contract, a concept they read into the Due Process Clause of the 14th Amendment.
Right.
They believed that an employer and an employee had a fundamental constitutional right to negotiate wages and hours without the government stepping in to set minimums or maximums.
And these men were deeply committed to this worldview. I read that Justice James McReynolds, in particular, stands out in the historical record as almost cartoonishly rigid and difficult.
Oh, he was notorious. He was fiercely anti-Semitic. He outright refused to speak to his colleague Louis Brandeis for years because Brandeis was Jewish, and he despised the modernizing world.
So these were not men who were going to bend to public opinion.
Not at all. They viewed themselves as the last line of defense for the traditional American republic. And they systematically began dismantling the New Deal, piece by piece.
The most devastating blow came in May 1935 with Schechter Poultry Corp v. United States, famously known as the sick chicken case. I want to spend some time on this case because the mechanism here is crucial to understanding the constitutional gridlock.
It really is.
How does a dispute over a local slaughterhouse selling a diseased chicken in Brooklyn threaten to unravel the entire federal recovery effort?
Well, it comes down to the National Industrial Recovery Act, or NIRA, which was the centerpiece of the early New Deal.
Okay.
The NIRA allowed the president to establish codes of fair competition for various industries across the country, dictating wages, hours, and trade practices to prevent a race to the bottom during the Depression.
And the Schechter brothers ran a poultry slaughterhouse in Brooklyn.
Right. They bought chickens that had been shipped in from other states, slaughtered them, and sold them to local New York retailers.
But they were convicted of violating the NIRA codes, including selling an unfit, sick chicken and violating the minimum wage and hour standards for their workers.
So the federal government steps in and says, you are violating the National Economic Recovery Plan. And the Schechter brothers take it all the way to the Supreme Court, arguing the federal government has no jurisdiction over their butcher shop.
And the Supreme Court agreed with the brothers unanimously. This wasn't just a 5-4 split. The liberal justices agreed too.
Yeah, the court ruled that the NIRA was an unconstitutional overreach. Their logic hinged on that strict interpretation of the Commerce Clause we talked about.
Because they said that while the chickens may have originally crossed state lines to get to New York, the stream of commerce had ended once they arrived at the Schechter's local slaughterhouse.
Exactly. Slicing up a chicken and selling it to a guy in Brooklyn is intrastate commerce. Therefore, the federal government had absolutely no constitutional authority to regulate the wages of the men sweeping the floor of that slaughterhouse.
It's a fascinating, deeply formalistic way of looking at the law. While the entire national economy is interconnected and collapsing, the court is drawing an invisible wall around a butcher shop in Brooklyn, saying the federal government's power stops at the door.
And they didn't stop there. In January 1936, they struck again in United States v. Butler.
This case targeted the Agricultural Adjustment Act, the AAA.
Right. The farming sector was devastated. Overproduction had driven crop prices so low that farmers were burning their corn for heat because it was cheaper than coal.
The AAA solved this by paying farmers subsidies not to grow certain crops, stabilizing the prices, but the court struck it down.
Because they ruled that agriculture, like manufacturing, is a local activity, not interstate commerce. The federal government couldn't regulate local farming quotas, even if the national agricultural market was in a death spiral.
Okay, put yourself in FDR's shoes in early 1937. You just won almost every state in the country. The people are begging for economic relief, and 4 guys who never have to run for office are deleting your laws.
It's maddening.
How does a president even process that level of constitutional gridlock without breaking the system? The political branches are trying to drive the tow truck to pull the country out of an economic ditch, and the judicial branch is standing in front of the tow truck, reading from an 18th century rule book, insisting that tow trucks are unconstitutional.
If we connect this to the bigger picture, Alexander Hamilton famously wrote in the Federalist Papers that the judiciary was the least dangerous branch because it possessed neither force nor will, but merely judgment.
Right.
But in 1936, the court's formalistic judgment was paralyzing the will of the entire elected government. FDR firmly believed that the Constitution was a flexible document that had to adapt to the massive, industrialized realities of the 20th century.
While the Four Horsemen believed they were upholding the sacred boundaries of liberty.
FDR realizes he is out of time. The Depression is happening right now. He can't wait for these elderly justices to naturally retire or pass away. They are holding on with a death grip.
And he can't pass a constitutional amendment redefining the Commerce Clause because the amendment process takes years and requires overwhelming state ratification.
Exactly. So he looks at the structural mechanism. He realizes the Constitution doesn't specify the number 9. If he can't change the minds of the men on the bench, he decides to change the math.
And this leads to February 4th, 1937. FDR stuns the nation, and even his own cabinet, by unveiling the Judicial Procedures Reform Bill. The sheer audacity of the mechanism he proposed is still breathtaking today. Walk us through exactly how this bill was designed to work. It wasn't just a simple, let's add 2 seats proposal, right?
No, it was a very clever, highly targeted mathematical formula. The bill proposed that whenever a sitting Supreme Court justice reached the age of 70 and possessed 10 years of service and declined to retire, the president would be empowered to appoint 1 new additional justice to the court.
And to a maximum of 6 new seats.
Right, expanding the court from 9 up to a potential 15. And the brilliant, or perhaps insidious part of this formula is that in 1937, exactly 6 of the sitting justices were over the age of 70.
So if Congress passed this bill, FDR would instantly have the legal authority to nominate 6 brand new justices.
He could flood the bench with New Deal loyalists, entirely swamping the Four Horsemen and guaranteeing a liberal, pro-government majority overnight. It was the nuclear option.
But what is so fascinating about this moment is how FDR tries to sell it. He doesn't go on the radio in a fireside chat and say, look, the Four Horsemen are acting as an unelected super legislature. They are destroying our recovery, and I need to pack the court to save the country.
No, he avoids the ideological argument completely. Instead, he uses a pretext.
A deeply dishonest pretext. He frames the entire massive power grab as a mundane administrative reform.
He claims the federal bench, and the Supreme Court in particular, is simply overworked. He argues that the aging, elderly justices are fatigued, they can't keep up with the complex modern caseload, and justice is being delayed for the American people.
He just lied. He said they were tired.
He presented the addition of 6 new justices as just bringing in some fresh, energetic blood to help the old men with their paperwork.
Which is spectacularly insulting to the sitting justices, regardless of their ideology. And it gave his opponents the perfect weapon to dismantle his plan, because the court wasn't actually behind on its docket.
Not in the slightest. Chief Justice Charles Evans Hughes, who was a brilliant administrator, ran the court with incredible efficiency.
Right.
When FDR made this claim, Hughes took the extraordinary step of writing a detailed public letter to Senator Burton K. Wheeler. In the letter, Hughes coldly laid out the statistical data of the court's docket, proving unequivocally that the court was fully caught up on its work.
There was no backlog.
There was no administrative crisis at all.
Hughes essentially called the president a liar using spreadsheet data. By making the argument about efficiency rather than ideology, FDR handed the Chief Justice the power to destroy the premise of the bill. He lost the moral high ground immediately.
And the most stunning part of this showdown isn't the Republican opposition. FDR expected that. He had massive supermajorities in Congress. He didn't need Republican votes. The devastating blow came from his own side.
The backlash from the Democratic Party was fierce and immediate. Institutionalist Democrats, men who had supported FDR, who had voted for the NIRA and the AAA, who desperately wanted the New Deal to survive, recoiled in horror at the court-packing plan.
Right.
Why did they turn on him so aggressively? If they wanted his policies to survive, why didn't they just vote to give him the 6 seats?
Because they recognized the long-term structural danger. Senators like Henry F. Ashurst, the Democratic chair of the Judiciary Committee, and Burton K. Wheeler, a leading progressive, looked at the bill and saw the architecture of a dictatorship.
They realized that if a popular executive could fundamentally alter the size and ideological makeup of the judicial branch simply because he disagreed with its rulings, the separation of powers would be functionally destroyed.
They realized that if FDR could do this today to save the New Deal, a future conservative president could use the exact same lever tomorrow to dismantle everything they had built. The precedent was too dangerous.
Exactly. They valued the structural integrity of the American Republic over the immediate policy victories of the 1930s.
The Senate Judiciary Committee, dominated by FDR's own party, didn't just quietly bury the bill. In June 1937, they released a report that remains one of the most scathing rebukes of presidential power ever penned by Congress.
Okay, let's unpack this. I have a quote from that report here. They called FDR's plan, quote, a needless, futile, and utterly dangerous abandonment of constitutional principle. They wrote that it was a measure that, quote, should be so emphatically rejected that its parallel will never again be presented to the free representatives of the free people of America.
Utterly dangerous.
This is his own party repudiating him. FDR had the numbers in Congress, he had the mandate, but he lost anyway. By its own text, the bill was a total defeat.
It was a humiliating, catastrophic legislative defeat for Roosevelt. He burned immense political capital, alienated his allies, and the bill died a very public death.
So, by all conventional legislative metrics, FDR lost the battle. He lost badly. Yet, if you zoom out from the congressional defeat and look at the actual output of the Supreme Court, a miraculous sequence of events unfolds. FDR lost the legislative battle in humiliating fashion. Yet, miraculously, he ended up getting exactly what he wanted from the court.
He unequivocally won the war, and that brings us to the most legendary, highly debated, and frankly mysterious sequence of events in Supreme Court history, the pivot.
Let's lay out the timeline from the dossier, because the sheer pacing of these events is incredible. February 5, 1937, FDR announces the court packing plan. The country erupts in debate. Fast forward just weeks later to March 29, 1937. The Supreme Court hands down its decision in a case called West Coast Hotel Comita Parrish.
This case involved a state law in Washington that established a minimum wage for women and minors. Elise Parrish, a chambermaid at the West Coast Hotel, sued for back wages.
Now remember, the Four Horsemen's rigid doctrine of freedom of contract. Just a few years earlier, the court had consistently struck down similar state minimum wage laws, arguing the government couldn't interfere with private employment contracts.
The precedent said Elise Parrish was out of luck. But on March 29, the court stuns the legal world. They rule 5-4 to uphold the Washington minimum wage law.
Wait, really? They explicitly overturned their own recent precedent?
Yes, it was a massive doctrinal earthquake, but it was just the beginning. 2 weeks later, on April 12, 1937, the court decides NLRB v. Jones and Laughlin Steel Court.
This was a challenge to the Wagner Act, which was a monumental piece of federal legislation guaranteeing the right of private sector workers to unionize, bargain collectively, and strike.
This is exactly the kind of sweeping federal economic regulation the court had struck down in the Schechter sick chicken case.
Exactly. But this time, in another 5-4 decision, the court upholds the Wagner Act.
They suddenly embrace a much broader interpretation of the Commerce Clause. They argue that a massive steel plant in Pennsylvania, even if the manufacturing happens in one state, is part of a larger stream of commerce. A labor strike there would paralyze the national economy, so the federal government does have the power to regulate its labor relations.
The invisible wall around the local business is gone. The constitutional roadblock that had paralyzed the New Deal is entirely dismantled in a matter of weeks.
And the central figure in this dramatic reversal, the man who changed the math without a single new seat being added, is Justice Owen J. Roberts.
Justice Roberts was a moderate conservative who had previously voted with the Four Horsemen to strike down early New Deal laws. But in the crucial spring of 1937, Roberts abandoned the conservative bloc.
He cast the deciding fifth vote with the liberal justices to uphold the minimum wage and the Wagner Act. His pivot shifted the court from a 5-4 conservative majority to a 5-4 liberal majority on economic regulation.
And as if the universe was tying a neat bow on FDR's victory, on May 18, 1937, Justice Willis Van Devanter, one of the hardcore Four Horsemen, announces his retirement.
That retirement was the final nail in the coffin for the court packing plan. Once the court began upholding New Deal legislation, and once FDR received his first natural vacancy to fill with a loyalist, the entire urgency behind the packing plan vanished.
Because why blow up the institution, alienate your party, and face massive political blowback if the court is already doing exactly what you want.
Over the next few years, natural attrition allowed FDR to appoint 8 justices, entirely remaking the court in his image without ever passing his controversial bill.
It is an unbelievable sequence of historical events,
Mm-hmm.
and it gave birth to a rhyme that has echoed through law schools and history classes ever since. The switch in time that saved 9. A brilliant play on a skitch in time saves 9.
It perfectly encapsulated the popular, cynical narrative that emerged almost instantly. The narrative goes like this. The court was threatened by a wildly popular president aiming a legislative gun at their heads. They looked at the threat of 6 new justices diluting their power. They panicked, and they caved to save their own institutional skin.
So wait, the court is supposed to be this dispassionate, neutral umpire calling balls and strikes. But the moment the president threatens to rush the field with 6 new umpires, they suddenly start calling a completely different game. Let me pause here and really dig into the implications of that popular narrative, because it is terrifying if you care about the rule of law.
Oh, absolutely.
We rely on the myth that the court is a dispassionate umpire. But if the switch in time narrative is true, the court isn't an umpire at all. It means that constitutional principles aren't grounded in legal philosophy. They are entirely negotiable based on the ambient threat level from the political branches. It suggests the court can be bullied into submission.
That is precisely why this episode remains so controversial and deeply unsettling. It strips away the majesty of the law and suggests that jurisprudence is just politics by other means. If threat produces capitulation, then judicial independence is an illusion.
But when we look at the archival evidence in this dossier, we have to play detective because the timeline introduces a massive, glaring contradiction to that popular narrative of capitulation.
The timeline is where historians and legal scholars start tearing their hair out. Let's steelman the skeptical view first, the argument that there was absolutely no political influence and that the court did not cave to FDR's threat.
Okay, wait, let me get these dates straight. Lay out the facts.
We have to look closely at the dates. The bombshell decision in West Coast Hotel, where Roberts supposedly flipped, was publicly announced on March 29, 1937. FDR announced his court packing plan on February 5, 1937.
So, to the public reading the newspaper, the threat precedes the action.
However, the Supreme Court does not decide cases the day they read the opinions from the bench.
Right, they hear oral arguments, and then they retreat to a private conference room to cast their initial votes in secret.
Exactly. And the historical records from the justices' private papers reveal that the conference vote for West Coast Hotel took place on December 19, 1936.
December 1936. Roughly 7 weeks before FDR ever breathed a public word about his court packing plan.
Yes. And in that secret December conference, Justice Roberts voted to uphold the minimum wage law. His decisive paradigm-shifting vote happened long before the specific threat of adding 6 seats was ever made.
As a detective, that breaks the causality. If the vote precedes the threat cannot possibly have caused the vote. You cannot be intimidated by a gun that hasn't been drawn yet. So when Chief Justice Hughes later insisted forcefully that the president's plan had not the slightest effect on their decisions, the timeline backs him up. It suggests that Roberts simply changed his legal mind organically. Maybe the lawyers in the West Coast Hotel case made a better argument. Maybe his internal legal philosophy evolved. And the timing of FDR's bill was just the most monumental coincidence in American political history.
That is the strongest defense of the court's integrity. Legal scholars have spent decades analyzing Roberts' prior opinions, pointing out that he had occasionally wavered and voted with the liberals in earlier cases, like a 1934 case regarding milk prices.
Oh, interesting.
They argue his shift was a logical, internal doctrinal evolution, completely divorced from the political drama outside the courtroom.
But let me push back on that, because nothing happens in a vacuum, especially not in Washington, D.C. Let's steelman the other side, the political pressure view. Even if FDR's specific legislative blueprint hadn't been announced in December 1936, what else happened right before that secret conference vote?
The November 1936 presidential election.
It's exactly the political earthquake. FDR wins 46 out of 48 states. It is a deafening repudiation of the conservative philosophy of the era. When Justice Roberts walks into that secret conference room in December, he doesn't know about a bill to add 6 seats. But he knows with absolute certainty that the president backed by the entire nation, is openly, furiously hostile to the court's recent rulings.
That is the core of the pressure argument. You do not need to see a specific legislative blueprint to feel the immense atmospheric pressure of a 46-state mandate. Furthermore, while the initial private vote happened in December, Supreme Court opinions take months to draft, circulate among the justices, and finalize. Justices can, and frequently do, change their votes during that drafting process.
A preliminary vote is just preliminary until the ink is dry and it's read from the bench.
Exactly. And during those critical months of drafting in early 1937, FDR does announce the packing plan. The ambient pressure crystallizes into an explicit existential threat to the institution. The public announcement of West Coast Hotel in March, and the subsequent votes on the Wagner Act in April, which were cast after the bill was announced, happened under maximum political heat. Defenders of the switch narrative argue that the sheer democratic gravity of the election, compounded by the later explicit threat, locked Roberts in. It forced the court to adapt to the political reality to survive.
So we're left with two completely plausible, fundamentally opposed narratives.
Right.
One, Roberts evolved intellectually in December and the February threat was just loud background noise. Two, Roberts felt the massive Democratic mandate of November, changed his vote out of an instinct for institutional survival in December, and the explicit February threat just ensured he didn't dare change his mind back. It is a genuine historical mystery.
What's fascinating here is that while we will never know the exact psychological mechanism inside Owen Roberts' head, the broader historical reality survives completely intact. Whether the specific threat flipped a specific vote, or whether it was just the overwhelming tide of history forcing an adaptation, the 1937 showdown proved beyond a shadow of a doubt that the Supreme Court is a political institution susceptible to the gravity of the political branches.
Put yourself in the robes of a justice during that time. You live in society. You read the newspapers. You see the breadlines. Can any human being truly entirely block out the pressure of a president holding a mandate of that magnitude, loudly telling the country that your legal formalism is destroying the economic recovery?
I don't think they can.
Even if you think you are just impartially applying the law, your subconscious has to be screaming, if we keep striking these laws down, the people might actually revolt.
It strips away the myth of the justices as legal automatons living in a hermetically sealed vacuum. They are human beings. The threat mattered more than the mechanism. The entire episode was a raw, bruising contest over the court's composition. Everyone involved, FDR, the Congress, the press, the justices themselves, understood that the court's makeup was a political prize.
It wasn't just a polite disagreement over the Commerce Clause, it was a battle for control of the constitutional machinery itself.
Which brings us to the legacy of 1937 and what this deep dive means for us today. Because the showdown left a complex, almost contradictory legacy regarding how Americans view the judiciary.
How so?
Well, it established a deeply conflicted precedent. On one hand, it seemed to solidify the norm of the nine-justice court. Franklin Roosevelt, at the absolute apex of his popularity, wielding massive legislative majorities, tried to break the norm of nine and failed spectacularly. This convinced generations of Americans that the nine-member court is practically unassailable, a deeply entrenched part of our unwritten Constitution.
The takeaway was, if FDR couldn't do it at the height of the Depression, nobody can do it.
Exactly. But, on the other hand, the outcome also proved that the threat of court packing could be a highly effective political weapon. FDR lost the legislative battle, but achieved his ultimate policy goals without altering a single comma of the Constitution. So historians constantly debate, did FDR's defeat establish a durable, sacred historical norm against court packing, or was it merely a contingent political outcome where FDR just happened to misplay his hand by lying about the overworked justice's pretext?
Let's contrast 1937 with 1866 for a minute, because comparing the two reveals the true mechanics of how this works. In 1866, Congress successfully shrank the court to 7, despite Andrew Johnson. They passed the law, it worked, he got no appointments.
Right.
In 1937, FDR tried to expand the court to 15 and failed. Both were raw, undeniable attempts to use congressional power over the court's size. Why did the maneuvers succeed in 1866 while it collapsed in 1937?
The answer lies entirely in the dynamic between the branches of government. In 1866, the legislative branch was united against the executive branch. Congress was fiercely determined to check Andrew Johnson's power. Shrinking the court was a way for the legislature to assert its dominance.
Well, that makes sense.
But in 1937, the dynamic was reversed. The executive, FDR, was trying to use the legislature to assert his dominance over the judiciary. And Congress, specifically his own party in Congress, balked. They realized that giving the president the power to pack the court would upset the balance of power too radically in favor of the executive branch. They checked the president to protect the long-term structure of the system.
That is the crucial distinction. The success or failure of manipulating the court size comes down to Congress's willingness to check executive power, even when they belong to the same political party. Ashurst and Wheeler valued the separation of powers more than they valued a quick victory for the New Deal.
And this historical debate isn't just academic trivia. It is incredibly relevant because we are hearing the exact same arguments echoing through the halls of power right now.
Yes, and let's be extremely clear and transparent with our listeners here as we touch on modern debates. When we talk about modern court expansion proposals, which are absolutely in the news cycle today, we are strictly analyzing how the rhetoric and the structural arguments mirror the history we've just covered.
Right. We are looking at the historical parallels.
Exactly. We are not taking a side. We are not endorsing or condemning any left-wing or right-wing proposals regarding the current Supreme Court. The historical sources we are working from present this as an ongoing, centuries-old debate about institutional design, not a partisan platform for today.
That is the most responsible way to view it. When you listen to the arguments today, claims that the court is out of step with the American public, demands to rebalance an institution that has become too ideological, or conversely, fierce arguments about protecting judicial independence from partisan manipulation. These are not new inventions. These are the exact same arguments that echoed through Congress during the radical Republican era of 1866 and the New Deal era of 1937.
It's just a different century, but they are reading from the exact same script. The arguments that institutionalists make today against court packing are the identical arguments Senator Wheeler made against FDR. The arguments advocates make today about the court obstructing democratic progress are the identical arguments FDR made about the Four Horsemen.
Which is why understanding this history is so utterly essential for a functioning citizenry. If you don't know that Congress structurally starved Andrew Johnson in 1866, or that they expanded the court to 10 during the Civil War to protect Lincoln's blockades, you might mistake today's political debates as unprecedented constitutional crises.
Right.
They aren't. They are merely the latest chapter in a long, continuous struggle over how to handle the founders' silence in Article 3.
So I want to ask a question that really gets to the philosophical heart of this deep dive. If the size of the court has always been this movable, highly political object, this lever that gets yanked whenever the socioeconomic stakes get high enough, why do we treat the number 9 today like it is carved in stone tablets? Is it just amnesia? Is it just because we haven't touched the dial since 1869 and we've collectively forgotten how the game of constitutional chess used to be played?
I think historical amnesia plays a significant part. When an institution remains unchanged for over 150 years, it creates a very powerful illusion of permanence. But deeper than that, I think it is about the fundamental necessity of legitimacy. A legal system requires the populace to believe in its underlying fairness and stability. If we constantly openly acknowledge that the Supreme Court is just another political battleground where the rules can be changed to guarantee a specific outcome, its rulings lose their moral authority.
We cling to the number 9 and the myth of the neutral umpire because the alternative, acknowledging that the structure of the law is just a raw political fight, feels too destabilizing to our civic religion. We need the myth for this system to function.
We rely on the illusion of architectural precision to feel safe in the house.
That is heavy. Okay, we have covered a massive amount of historical ground today. Let's summarize the journey we've taken through this dossier. We started with the shocking revelation that the Constitution contains no blueprint for the court size. We watched the number seesaw in the early 19th century from 6 to 7, up to 9, and up to 10, ostensibly for geographical circuit riding, but always with an eye on ideological control.
We saw the radical Republicans weaponize that size in 1866, shrinking the court simply to spite Andrew Johnson and deny him generational influence over Reconstruction.
A pure legislative starvation tactic. And then we watched them magically bring the seats back for Ulysses S. Grant in 1869, cementing the number 9 purely out of political convenience. Then we moved into the desperation of the 1930s, watching a wildly popular FDR, armed with the 46th state mandate, smash into the immovable, formalistic wall of the Four Horsemen. We saw him propose his radical, cleverly disguised plan to pack the court to 15. We saw his own party rise up and brutally strike the plan down in defense of the separation of powers.
And finally, we explored the enduring, unresolved mystery of the switch in time. We steelman both the cynical view that political pressure forced Justice Roberts to abandon his conservative jurisprudence and the archival evidence suggesting he found his way there independently in that secret December conference before the threat was ever made. The ambiguity of that moment defines our modern relationship with the court.
So what does this all mean?
It means that the core thesis of our deep dive today holds true. The Constitution left a deliberate or perhaps accidental blank space regarding the court's size, and like a vacuum, politics naturally rushed in to fill it. Alexander Hamilton called them the least dangerous branch because they lacked the sword and the purse. But history shows that the political branches have always been willing to use their structural power, their legislative will, to keep the court in check when they feel it has overstepped. The court's composition is, and always has been, contested terrain.
It is a profound shift in perspective, and I want to leave you, the listener, with a final thought to mull over on your own as you go about your day. We established that we rely on the myth that the Supreme Court is above politics. We need that myth for the institution to maintain its legitimacy, for us to accept its rulings even when we violently disagree with them. But if knowing this history, knowing that the court's size and composition have always been a raw, sometimes spiteful political battlefield, if that knowledge shatters the myth of the neutral umpire, does that make the institution dangerously weak? Does it threaten the rule of law itself? Or, by stripping away the illusion of absolute precision, by acknowledging the messy human reality of how the blank spaces are filled, does it actually make us healthier, more engaged, and more realistic citizens regarding how American democracy actually functions?
It forces us to take responsibility for the institutions we build and maintain, rather than blindly assuming they run on magical constitutional autopilot.
Exactly. The blueprint was never finished. We are the ones who keep drawing the house. Thank you for joining us on this deep dive into these incredible historical sources. Keep questioning the narratives you've been taught. Keep looking for the missing pages in the blueprints, and we will see you next time.